to this Expert Voices seminar hosted by the Centre for Justice Innovation. My name is Phil Bowen. I'm the director of the Centre. Again, just to go back through some housekeeping for those who just joined, please keep your cameras off and yourself muted so we just don't disrupt the excellent speakers we have today. And also just to let you know that my colleague Miranda has already started recording this session and it will be available on our YouTube channel after. I'll just start a little just by saying a little bit about the centre itself. So the Centre for Justice Innovation is a not-for-profit organisation that seeks to build a justice system which every citizen believes is fair and effective. To deliver that vision, we provide hands-on support to practitioners doing new and interesting things. We conduct research into how things are working right now and how they could be better in the future. And we promote evidence-based and innovative justice policy reforms. It's been said in the recent past that some people have had enough of experts, but we at the Centre don't believe that. We have not had nearly enough of experts, and today's event is the latest in a line of expert voice seminars, and you can see previous ones on topics like neurodivergence in the criminal justice system on our YouTube channel. The Expert Voices event series that this is part of is an attempt to discuss kind of the key issues affecting the justice system, and it's free and open to everyone. And it's part of a much wider programme of work that we do at the Centre to promote the voices, in particular of practitioners and academics who are leading on crucial issues that cut across justice systems across the UK. We also have a series of expert voice blogs, and also on our map of innovation, we chart innovative projects that are happening right across the UK's justice systems, whether that's youth justice, adult criminal justice, or family justice. So today's seminar, as you know, is about the presumption against short prison sentences, and in particular, the Scottish experience of that. And we are very privileged to have two excellent speakers who will speak for roughly 15 minutes each, leaving hopefully ample time for Q&A at the end. So I will start with a short introduction to the topic just to provide some context to the discussion before handing over to Chris McCully, the head of policy at Community Justice Scotland, and then to Professor Cyrus Tata, Professor of Law and Criminal Justice at Strathclyde University. And they will both speak about the impact of the presumption. Once we've heard from them, we'll open up to the Q&A. I'll probably grill them on some of the things they've said, and you can submit your questions throughout the event using the Q&A function. So we hope you enjoy that. So without further ado, we're going to do a slightly Chris Whitty style set of presentations. So I will be saying to my colleague Miranda to just put the presentations up and to go through the slides. So in terms of the kind of policy context for us, so the reason that we wanted to hold this session is, as some of you will know, there is a sentencing bill in front of the House of Parliament. Next slide, please, Miranda. So the policy background is that Alex Chalk in October, the Secretary of State for Justice, announced plans to legislate for a new presumption against short prison sentences of 12 months or less. This was part of an announcement he made with a backdrop of concerns about prison capacity in England and Wales. Most recent prison population figures show that the prison population is very close to the usable operational capacity in the adult male estate in particular. Our latest prison population projections for England and Wales suggest that population is set to rise to almost 95,000 by March 2025, and possibly even over 100,000 by March 2027. As part of his announcement, the Lord Chancellor announced this desire to legislate for the presumption, but also announced an executive release scheme, letting people out of the system, a system that is just overcrowded. And it also meant that further prison population projections have had to be delayed due to the policy announcements made on the 16th of October, and we're anticipating a new set of prison population projections in February. Next slide, please. So just a little bit about the Scottish presumption, and I won't go through this in detail because our two excellent speakers will do it. Will give it much better justice than I can. But just for kind of basic backgrounds, in 2011, there was the presumption against the use of short prison sentences of 3 months or less was introduced in Scotland. That was a move aimed to avoid sending low-level offenders to prison and giving courts the power to let them complete their sentences in the community. Just by way of context, community sentences are supervised by criminal justice social workers. Community Justice Scotland, which was established in 2016, that Chris is the head of policy for, plays a national oversight role in coordinating activities to promote early intervention, prevention and community sentences. So Community Justice Scotland plays an important role in that presumption. The presumption that was introduced in 2011 was then extended in 2019 to be a presumption against prison sentences of 12 months or less, so very similar to the intentions in England and Wales. Next slide, please, Miranda. So just in terms of just some relevant research, so there was some research done about judicial decision making around the presumption, which seemed to suggest in 2015 that it wasn't making much of a difference to how sentences behaved. During the debates in the Scottish Parliament in 2019 about raising the presumption against short sentences from 3 months to 12 months, there was a certain amount of controversy about that extension, with Conservative MSPs in particular dissenting from that plan, with the chair of that particular committee, even though it passed, saying she wasn't convinced this was a sensible way forward. And I think in general, especially because of the impact of COVID, it's been quite difficult to work out what the impact of the extended presumption is on short prison sentences, given the overall impacts of COVID on volumes going through court, volumes going to prison. Next slide, please, Randa. So just again, by way of context, the Scottish prison population has been steadily rising over the past sort of 20 years. This is Scottish Government data that we're presenting here. So, and obviously the presumptions against have been introduced within that period. So one of the things we'll discuss during the course of this seminar is the impact of presumptions on the overall levels of the prison population. Next slide, please. Just looking at sort of the trends in Scottish sentencing. So this is just the kind of raw figures on community sentences, which is the top purple line, and then prison sentences of selected of 0 to 3 months, 3 to 6 months, 6 to 12 months, 12 to 18 months, which shows that there's been a sort of general trend of falling prison sentences, but of short prison sentences, I should say, and community sentences have kind of sort of bobbled along, sort of rising and then dipping, and then obviously you can see with the pandemic a big dip and then a rising again. Next slide, please. And so just to look at that in terms of the rate of change, I think one of the things that's interesting is, for example, if you look at the orange line, 0 to 3 month prison sentences in Scotland seem to have declined quite significantly. So if you take the whole period from 2009 onwards, 0 to 3 month sentences have reduced by 78%. Since the introduction of the first presumption against, by 66%, and the second presumption, or the extension of the presumption in 2019, by 36%. So there seems to be something going on, but cause and effect is always quite difficult. And that's why we've got two excellent speakers who are going to unclutter the confusion, tell us exactly what's been going on in Scotland, and tell us what the impact of the presumption is. So without further ado, I will hand over to Chris to give his perspective before then handing over to Cyrus.
Thanks, Phil. Yes, thanks very much for that excellent introduction. I think it sets out some of the key questions and considerations very clearly. I'll just be speaking directly at you. I haven't got any slides today because I think there's much better ones from Phil and later from Cyrus. So the talking head might be a nice break in between. My sort of aim is to set out a little bit of the sort of Scottish context, some of the kind of general policy context, look a bit more at some of those numbers and trends, and whether or not we think the presumption has been successful, and then look at maybe a bit about why the implementation and the actual change has been slightly less, perhaps, seismic than we might have hoped for, or at least certainly than was the initial policy intention for the introduction of the presumption, and then a little bit about what might that mean in relation to the English and Welsh presumption that's being introduced through the sentencing bill. So in terms of the general context, I think as Phil pointed out, the introduction of the presumption is now well over a decade. In its first instance, it was for 3 months, and it was extended then to 12 months in 2019. And that's against a backdrop, I think, that would generally be fair to say is a pretty progressive penal policy backdrop in Scotland over the last 20 years and indeed beyond. There's been a concerted shift, I think, in justice policy to try and prioritise community approaches to justice and to sentencing. That's been going back a long time. But for example, at the same time, the initial 3-month presumption was introduced. There was the act that introduced that also introduced the community payback order, which is a community sentence that can have a range of different aspects attached to support someone to deal with their offending and to pay back to the community in their local area. We've also had developments like the establishment and then disestablishment of the community justice authorities. We had the Community Justice Scotland Act in 2016, which created Community Justice Scotland, but also set up a local model for supporting community justice approaches. So all the kind of community orders, release and reintegration, resettlement support, diversion, all there's now local partnerships set up across the country that aim to support and facilitate that, bringing together a range of local partners to sort of take a cross-sector, multi-agency approach to helping to support reducing offending and reoffending. And all of that is also supported by recent sort of national strategy for community justice and the justice provision, which the Scottish Government set out in the last few years, that very clearly states the intention to shift from custody as a first approach to offending behaviour towards one that's rooted in communities and community justice. Alongside that, we've also seen a range of legislation over the last 5-10 years looking at introducing and expanding the use of electronic monitoring, changes to bail and release from custody, most recently trying to support sort of improved reintegration for people on short and long-term sentences, and generally speaking, I think that's a backdrop that is one that would, in theory, be conducive to some positive changes. And I think certainly there have been a number of successes over the last while. But I think part of the challenge when looking at the presumption is obviously what does that look like in practice? Before I go on to have a bit of a discussion about that, I think it'd be useful maybe to set a bit more context about how the Scottish presumption works. The presumption that's being proposed in England and Wales is quite different. The Scottish presumption is, as I say, it was initially for 3 months and extended to 12 months, but the wording is quite specific. It's that a court must not pass a sentence of imprisonment for a term of 12 months or less on a person unless the court considers that no other method of dealing with the person is appropriate. So that's very different from the English and Welsh proposal, which is that all sentences of under 12 months are automatically sort of commuted to a suspended sentence unless there's a reason for not doing so. So that changes, I think, the sort of flavour from the start, and it puts the emphasis on sheriffs to be thinking about, well, what community options are there available in a local area, and how could those be applied in the instant case. So that's, I think, is an important distinction. And as Phil pointed out, the administration of non-custodial sentences is the responsibility of local authorities in Scotland, and that's usually administered by local justice social work teams. So that's obviously a considerable difference to England and Wales, where you have a probation service now, and obviously you've had a decade or two of tumultuous change in that front. But in Scotland, we have 32 local authorities. So we have 32 different social work agencies, each of which are guided by their statutory duties, legislation, guidance, inspection at a national level. But the practice, their resources, their approach and their structures and what local services they are able to integrate in with changes considerably across the country. So another big part of considering community sentences in Scotland is looking at the role of the third sector as well. So voluntary sector organisations play a massive role in supporting the delivery of community sentences, whether that's as a specific part of an order, for example, providing other activity requirements under a CPO, or providing general support alongside a community sentence. So they're a big part of this delivery landscape as well. So that, I think, is important to bear in mind, because the sort of nature of the presumption, the delivery context, I think, explains to some degree, I think, sort of what's happened a bit with the numbers. If we were to look at, I think, what the effect of the presumption has been, well, Phil's already touched on it in his introductory slides, but I think I was joking before the session that I think I could probably just sum up this section by saying it's all very messy and nobody quite knows what's going on, but that wouldn't be a very interesting or engaging presentation for you to sit through. So I think I'll try and unpick a little bit more, but I think the long and short of it is that it's quite difficult to know what the effect of the introduction of the presumption has been, partly as a result, as Phil points out, the pandemic is kind of clouding the analysis, certainly in relation to the extension of the presumption. I think there's been some evidence to suggest a decrease in the use of sentences under 12 months since the introduction of the extended presumption, but that's quite difficult to separate out from potential effects of the pandemic, or maybe other things that are at play. Certainly one of the things that we've seen is that the pandemic is driving more complex and in some instances serious patterns of offending for some people in the justice system. So it might be that they're getting picked up through other options, and there could be a whole range of different drivers of that slight decrease, which I think the Scottish Government puts at about 4%. I think in their most recent sort of statistical update, there's been a 4% decrease in the use of sentences under 12 months. But generally speaking, I think there's a bit of a lack of research and evidence about what the effect of the presumption has been. Phil alluded, or the presentation alluded to the evaluation in 2015 of the 3-month extension, which was, I think, inconclusive. Certainly, would be putting it mildly. I think some sheriffs indicated that actually, rather than influencing them to give a community order, it was more likely for them to impose a more serious sentence as a result of considering the presumption. So I think that suggests that there's certainly mixed responses to it. I think what we generally aren't very good at, and certainly in relation to past, but I think more generally in justice systems everywhere, is actually recording data and looking at what the effects of a change have been. So while the legislation for the Scottish presumption provides for sheriffs making and recording their decision making and setting out the reasons why they don't think a community order would be appropriate and that it has to be a custodial order, there's no concerted collecting of that information. So it will be recorded in the court records, but it isn't necessarily then gathered and analysed and subjected to a sort of qualitative analysis of any kind, or even quantitative analysis. So that means that it's difficult, I think, to understand what's happening in the context of presumptions. So I think we can see that there has been a clear drop, I think, across short sentences of under a year since the introduction of the presumption, but untangling, I think, causation is difficult. I think, given the policy context that I set out before and the kind of general shift And the fact that I think that it's been falling across all sentence lengths under a year rather than just the 3 months that the presumption was initially set out for, I think that would suggest there's something else going on rather than just the effects of the presumption that is driving that behaviour. And I think it's a classic kind of bottom up or top down kind of policy conundrum. Is it a reflection of changing attitudes on the ground that has led to this legislation, or has it influenced it? I think the jury's out on that slightly, but certainly the introduction in 2011 of the community payback order, I think the general trend towards community justice would suggest to me that I think there's other things at play rather than just the presumption in and of itself. So while we're seeing some changes, I think what's important to bear in mind that we're still looking at around 75% of all custodial sentences given out in Scotland being for a year or less, and that is really quite substantial. In terms of raw numbers, that translates to about 5,600 sentences a year of 12 months or less. And that the latest data we have for that is 21-22, so it'll probably be higher than that when the next one is out, because obviously that's a pandemic year. But the prison population figures for 22-23 suggest that that's probably that hasn't gone down. It's stayed the same or gone up certainly since then. Overall, I think if we're looking even at the sort of the sentences of less than 3 months, which arguably at this stage have had sort of 13 years of a presumption saying they shouldn't be given out unless it's kind of totally inappropriate to do so, they still represent 23% of all custodial sentences handed out in Scotland. Over the 13 years since its introduction, that's a reduction only of about 6%. So in 2011, they represented 29% of all custodial sentences handed out. So I think if we're looking at kind of raw numbers, while there is clear evidence of a decrease, actually we're still looking at certainly not a seismic shift, and not the seismic shift that was sort of envisaged certainly in the policy intent of the legislation. And what we're seeing is, I think, as you would expect, if the numbers aren't shifting that much in terms of how the courts are behaving, it's not translating through into substantial changes in the prison population. As Phil pointed out, we've got a rising prison population in Scotland, which I think the most recent figures are looking like we're currently sitting around about 8,000, and it's projected, I think, to rise to about 8,500 in the next year to 2 years, which I think would be the highest the Scottish prison population has ever been. The numbers of people going through prison obviously is still high, and there's obviously those high numbers of short sentences are having an impact on that. But the pardon me. The main drivers of the rising prison population are, I think, things like increasing sentence lengths generally. They've got a backlog or sort of throughput of historical offences that are driving it. In Scotland, we've got a stubbornly high remand population since the pandemic, and we've also had a tightening of the kind of release mechanisms at the kind of back end of the system. So things like early release on home detention curfew has been tightened up considerably in the last 5 years. There was the removal of the automatic early release for long-term prisoners at the sort of 2/3 mark, and it's now much closer to the end of their sentence. And we're also seeing a bit of a failure in the parole system, certainly in terms of people who are in prison who are longer term. They're not able to get the early release they would have liked. So that, I think, drives the prison. So really, actually, if a presumption against short sentences is going to shift it at all, it needs to be a really total change in the way we do justice, because of how the prison population works generally. There's a significant amount of churn in the population, which means that short-term prisoners are out and in and out and in, sometimes multiple times within the space of a year, on a given day, they're around about 13% of the population, even though over the course of the year, they're about 75% of the total population. So you would need something pretty substantial. So why hasn't it seen some of the changes that we would like to think it would do? Well, I think in relation to the first point I would make is that obviously that definition of how Scotland has implemented the presumption leaves a substantial amount to judicial discretion, and I think you could drive a horse and cart through the definition of appropriate that sits at it. And I've yet to, I think, meet a sheriff that would say a decision they made was ever inappropriate, and that, I think, tells you all you need to know about
1 minute, Chris.
1 minute, sorry, Phil.
That's right.
I am massively over my timing. I'll race through this. But I think the challenge, obviously, is that judges and sheriffs in Scotland are at the sort of they're what Lipsky would call street level bureaucrats. They are the people that are implementing policy decisions, and ultimately whether or not a policy works the way it's intended to depends on how they interpret it. They're subject to lots of different guidance, guidelines, statutory amounts, purposes and policy principles of sentencing that drives how they behave. And I think that means that determining what is appropriate is not necessarily going to be a community order. But there's also a structural logic in the justice system, I think, that creates challenges. So it's generally one of escalation. If you've got a pattern of offending, or if it's a serious offence, or you've breached an order before, then the system says, well, generally, that's not appropriate. Next time we have to keep amping it up, or prison is the last resort. But I think a second problem for the Scottish context is that the fact that we have to consider, rather than there's not an automatic option in the form of a suspended sentence, there's a choice has to be made. So the judiciary have to be able to identify a suitable option in a local area to provide that service and to provide that community order. So there's massive challenges with that in terms of funding, in terms of the fragmented nature of justice social work as a profession. Sheriffs are often working across multiple different local authorities. They're not always aware of what's available. Where is available, the challenges with funding mean that there's significant difficulties with the sustainability of services, with the availability and accessibility of them if numbers are very high. And that all, I think, means that it makes it difficult for sheriffs sometimes to have confidence in those options. And that's certainly something that we've seen in recent qualitative research published by the Scottish Government in relation to bail decision-making processes, where sheriffs weren't happy that the service was of sufficient quality and wasn't readily accessible. They weren't using it. So I think all of those mean that the actual uptake is probably lower than we would like to have seen. And it drives, I think, some reduction, and I think it changes. There's an important communicative aspect to the presumption in that it ties in with that clear direction of travel, but actually the nature of the structure, the challenges of delivering services for people on community orders, and the funding pressures and all of that combines to mean that actually the uptake is more limited than we might have hoped. So very, very shortly, what does it mean in terms of the English and Welsh presumption? Well, I think definition and how you define it is key. Obviously, the bill is now at its second reading, so that creates challenges for refining and changing that. But the more leeway, I suppose, there is to not use the presumption, and the less it will be used, I think is a pretty evident conclusion, and it's one that's backed up by other justice policy research, certainly in relation to restorative justice in Northern Ireland and all sorts of different things. But I think one thing that I would say that's really clear from the Scottish context is that there needs to be really clear monitoring and evaluation and research continuing after the introduction of the presumption to understand what the effects are, how it's being approached by the judiciary in England and Wales, and what the potential developments for future might be. And finally, they need to be convinced that the community options, or in this case, suspended sentences, is viable, that it's robust enough, that it's not going to risk public, and that alternatives and support is available to encourage them to do so. So that requires, in some sense, funding, but it also requires good information sharing. It requires good relationships at a local level, and it requires local support for implementation. And I'll finish on that. And apologies for running over, and apologies for the whistle stop tour, but it's a lot to fit in.
That's really, really, really helpful. And I know there's a lot to communicate, and it's fine, because as we know from our experience, when you need someone to keep to time, look to an academic, because they never overuse their time. So Thank you very much, Chris. Cyrus, I know you've got a presentation which Miranda will upload now. Be really useful to get your view on it. And if we can get through like in 10 or 15 minutes, I'll give you a kind of minute's notice, and then we'll get into some Q&A. And for people who are wanting to ask questions, please there are already some questions in the chat, but just please do put them in the Q&A. Okay, over to you, Cyrus.
Thank you so much, Miranda. We can just lose the slides for the moment, if you don't mind, and I'll just speak without them for the moment. Thank you so much, Miranda. Hello, everybody. It's a pleasure to be with you. Thank you to Phil and to all his colleagues for organising this seminar on this really important topic, and it's a pleasure to speak after you, Chris. I've had a look at the guest list, and you're a really interesting group of people, all of whom I strongly suspect are interested in a problem we've been trying to grapple with now for at least 5 decades. And that is, how do you reduce the use of imprisonment in terms of people who pretty much everyone agrees shouldn't be in prison? Ideally wouldn't be in prison. So we're not talking about serious offenders. We're not even necessarily talking about prolific ones. We're talking about people who everyone tends to agree whose needs are so chronic and serious that their needs often outweigh the seriousness of their offending, but they end up in prison. And they end up in prison not because of anything wrong necessarily which individual practitioners, judicial sentences, prosecutors, defense lawyers, probation officers and so on are doing, but because of a cultural problem we have. So I'm really suggesting that we need to think about this problem long term. And I know people say, goodness me, long term, couldn't we fix this in the next year? And naturally, politicians and sometimes policymakers have very short time horizons. But I just remind you, we have been trying to do this for 5 decades. And actually, as I'm going to explain, nothing in this is very new, in fact. So we really need to stand back from things. I share the skepticism, and always have done, actually, ever since the proposal came out way back in 2010, in fact, before 2010, about the idea of a presumption against short custodial sentences. I remain of the view it's unlikely to make any difference really in England and Wales. To the extent that there's been some changes in Scotland, I strongly suspect that they're more attributable to what you in England would call out-of-court disposals, the huge increase in out-of-court disposals, changes in policing and prosecution practices rather than in sentencing changes. And I'm going to suggest to you that actually logically it's completely unsurprising that this presumption makes any difference in Scotland, or in fact is likely to make much difference in England and Wales. But how do we reduce the use of imprisonment for people that don't need to be there, that we all tend to agree shouldn't be there, but end up being there for want of services in the community, for people whose needs are so chronic, who are blighted by homelessness, addiction problems, mental health, serious chronic mental health and physical health problems, neglect, abuse, and so forth. What do we do here? What do we need to do as a society? So my target, must emphasize, is not individual practitioners. It's too easy to blame members of the judiciary for sentencing. It's too easy to blame prosecutors and others. We need to think about this collectively as a society. And I have a proposal to put forward. But if I could ask Miranda, if you could possibly produce the first slide, that would be great. Thank you, Miranda. This is going to be a little bit like, if you remember the COVID days with Chris Whitty. Next slide. So how do we end the default to prison? I'm going to suggest that actually we use imprisonment as the default option in our society. We use it when nothing else seems to be available. We use it for want of community services, whereas prison is always there for us as the dependable backstop. We assume it just has elastic walls and prison will take anyone. When no one else wants them, prison will take them, even if their offending isn't serious enough to warrant imprisonment. Next slide, please, Miranda. So we've been trying a policy. It's often called last resort. And we've been trying this for over 40 years, in fact, over 50 years. And it sounds very progressive. And many people would say, what we need to do is to make imprisonment the last resort, because if you can make prison the last resort, then we'd use prison much less. And I'm going to suggest to you that this last resort thinking is part of the problem. I'm going to link this then to the presumption in a moment. There's a quote here that says we should use prisons as sparingly as possible, and that's inevitable for violent offenders, but we must question whether short periods of custody are appropriate for some of the less serious people who have committed less serious offences, especially where their needs are considerable. I wonder who said this. Miranda, could you click the return button? I don't know if anyone remembers this guy. Those of you who are of a certain vintage like me possibly recall him. This was the then Secretary of State for Scotland under the Thatcher administration, speaking in 1980, who argued for more last resort, Malcolm Rifkind. And many people saw Malcolm Rifkind, as arguably was, as quite a progressive guy, a sort of Rory Stewart of the early days, if you will. And he argued for last resort. Could we have the next slide, please, Miranda? Thank you. And he said we should make it much more unlikely that the use of imprisonment will be used except as a last resort by the courts, and we should encourage that prison is the last resort and is the place where people should go only where there is no other course to take them. And as I'll come back to, that's the problem, is thinking of it as only where there's no other course to take them. But the prison becomes used as our dumping ground in effect. Okay, let's move to the next one. Cycle forward to around the mid-2000s to 2010 and the run up to the referendum campaign in Scotland for independence. Regardless of what you think of that, there was a lot of discussion about whether or not Scotland could be a different kind of society. Could it be a more Nordic style society? Could it be a more social democratic, more inclusive country? What kind of country could Scotland be if it was independent? And criminal justice and the idea of the presumption was part of that. So this appears to be very bold. And along we get with the next slide, the presumption against a sentence of imprisonment. And section 10 of the Act, it wasn't introduced for a couple of years afterwards, but of the 2010 Act said, a court must not pass a sentence of imprisonment for, at the time, 3 months, as Chris has mentioned, later got extended to 12, on a person unless the court considers that no other method of dealing with the person is appropriate. Now, the first thing is all legislation rightly is caveated. It rightly has its exceptions. This is about as permissive an exception as you could get. And I've looked at the clause 6 of the sentencing bill in Scotland, and in fact, it's also extremely permissive, because when you then start to look at that and you say the court shouldn't pass a sentence of less than 12 months unless the court is of the opinion that there are exceptional offender and offence circumstances. And then it also lists a whole series of various exceptions as well. But I ask you, which court, which judge, which member of the judiciary, which person makes a serious decision which they consider to be inappropriate, which they don't consider to be correct? Of course they consider it to be correct, and rightly so. So really that doesn't take us anywhere. And the key point about this, if you just click the return button again, Miranda, is that in fact, although it doesn't use the term last resort, this idea of the presumption both in Scotland and in England and Wales is just more of the same thinking. It's last resort once again, which is don't do it. If you can think of something better, then don't pass a sentence of imprisonment. But if you can't think of anything better, then it's going to be imprisonment. And as I say, this is not the fault of individual sentences. This is a failure to resource community services properly. And we're using prison in lieu of that. So if we could have the next slide. The 3-month presumption we did the evaluation, we looked at that, and we concluded that it's had little impact on sentencing decisions. And as one sentencer said, Really, when I'm imposing short prison sentences, that's when I've run out of options. And that's entirely consistent with last resort thinking. If I can't think of something else, if nothing else is proving itself, and this is what the legislation says, then it's prison. So what happens is that people whose needs are great and no one else wants them, community services don't want them, community justice gets fed up with them, they don't turn up for appointments, their lives appear to be chaotic, but they're not a danger really to anyone except for themselves. They end up in prison because no one else will have them. And that's how we continue to use imprisonment today. We are little different to the way the Victorians used imprisonment, essentially for poverty-related reasons. And that is not to point the finger at individual practitioners who are burdened with this problem. So if we could have the next slide. The consequences of all of this, and if you could do 3 clicks, please, is that we're pouring more money into prisons. The argument is to make prisons more humane. That's obviously a good thing. But we couple this with cuts to community justice and to community services more generally, and it means more and needy people get sucked into prison. And as we know, that once you've been in once, you're more likely to go in again. People end up spending a life sentence by installments, short installments. And if we could have the next slide. And I must emphasize again, pointing the finger simply at individual practitioners, judges, and so forth is lazy and is actually a distraction. The whole idea of last resort as a policy option has actually let governments, successive governments, off the hook, because it sort of shuffles the problem over and says, oh, well, sentences will decide this, or prosecutors will decide this. When actually often they feel, well, there's no one that will take this person. And I've had so many conversations and seen it so many times, and I'm sure many of you are well familiar with the problem of this person isn't dangerous, but no one wants them. What am I supposed to do? The only place that will take them is prison. And that's the huge mistake we're making, is that essentially last resort burdens individual practitioners with having to shoulder our chronic societal failures, failing to resource community services and community justice, whereas prison seems to have elastic walls. And so if we have the next slide, what should we do? We need to change the last resort so it no longer becomes the default. Last resort essentially means that if you can't think of anything else, there'll be prison. Prison's always there on the table, even if the person doesn't appear to justify imprisonment in terms of the seriousness of their offending. So we need to drop that. Rather than saying alternatives, so-called, need to prove themselves, prison needs to prove itself, and we need to properly justify that. If you click again, please. And we also have a habit, through good intention, all of us, of using imprisonment sometimes as a place of sanctuary, sometimes as a place of safety, often for women or for young people, through good intention, because nowhere else seems to be a safe place, and we end up using prison. And especially where prisons seem to be humane, the temptation is always, and there's a long history of doing that, sending women to prison, and this is not the fault of individual practitioners, because nowhere else seems to be a safe place for them, and no one else will take them, even though their offending isn't sufficiently serious to warrant imprisonment. So my last proposal, or my proposal is, if we go to the next slide, is a 2-part principle. We need a target date to do this because we can't do this overnight. And once again, I emphasize the point, this isn't the responsibility simply of individual practitioners who are trying their best under often impossible circumstances. We need as a society to say, we have a target date, for example, 2035. If that seems like a long time away, remember we've been trying this for 50 years, so it's really not. We need a target date to concentrate our minds, rather like climate change, and say 2 things. 1, imprisonment can only be used if warranted by the seriousness of the offending. Only for that, not because there is nowhere else will take them. And secondly, that no one gets sent to prison for help, that it shouldn't be a ground for sending someone to prison. Of course, when people are sent to prison, because the seriousness of their offending is such, and if they're rehabilitated, that's a good thing. But no one should end up in prison for want of community services. So really what I'm trying to say is two things. One is that the presumption against short sentences doesn't seem to have had much of an impact in Scotland. To the extent there's been any changes, it's probably dwarfed by out-of-court disposal and prosecutorial and policing changes. That the presumption against short sentences is not, in fact, a new idea at all. It's simply last resort policy in new words. And last resort is something we've been trying for at least 50, 60 years with little effect, because last resort essentially leaves prison as the assumed backdrop, including for people who we all agree shouldn't actually be in prison at all, but end up in prison for want of help in the community and support in the community. And we need to shift money from the incredibly expensive resource of imprisonment, start closing prisons, have a target date to do that, towards community justice. That's the only way we're going to make a difference. I don't think, unfortunately, the presumption is going to make a huge difference. Thanks very much.
Thank you very much, Cyrus. Really provocative, really interesting, and constructive as well, which is great. I'm just going to ask one question to you, just on the back of what you said. So you said in your comments, Cyrus, that all of us on the call probably agree there are people who shouldn't go to prison, who aren't a danger to the public, but there are some who would say that some of the people who commit multiple low-level crimes are a nuisance, or create, actually they do create harm by shoplifting continually. What do you say to people who maybe take a more kind of punitive attitude, that they're, if you break the laws repeatedly, there needs to be some kind of consequence? What's your answer to that?
Well, yeah, well, of course there does. And the question of assistance, as it's sometimes called, is one, I don't necessarily have a problem with that myself. I do think, Phil, there's a lot of consensus in the criminal justice community, like have been knocking around this for decades, and everybody says the same, which is they're often incredibly, and members of the judiciary, incredibly frustrated by the fact that I don't want to send this person to prison, but no one else will take them. What else do you expect me to do? It's all very well, the rest of us wagging our fingers at them and saying, why are you sending this person to prison? They shouldn't be in prison. But no one else wants them. And the reason why no one else wants them is because we were starving community services and we're starving community justice, and we just allow imprisonment to grow. In terms of public attitudes as well, just a reminder, and it may be something CCI has covered previously, when we do the research on public attitudes in terms of punishment, and this is a finding consistent in many countries, and that is that when you ask people in the abstract, should we use more prison, should we be tougher, just about everyone says yes, we should be tougher. But when you give them actual scenarios and say these are the kinds of things the court's having to deal with, people are often very sympathetic, to the point where, for instance, rehabilitation. They're very aware that drugs is very problematic. They're very aware that you can get drugs in prison because there's a hopeless population there that will always have demand for drugs. And they do want to see change. So I'm not as pessimistic necessarily about this. I think once we actually get down into, when you look at case scenarios, yes, if you just talk in the abstract and say, should we be tougher? You can get, that's easy claptrap, let's be tougher on crime. That's easy. But when you actually ask people, they tend to be much more sensible, in fact, than we give them credit for, and then often the red top newspapers give them credit for.
Well, I mean, I think that's a message that's really important in this year, which will be an election year, where we may see people appealing to those kinds of sentiments. Chris, you outlined really usefully in your presentation a sort of progressive backdrop to the presumptions in Scotland. One of the people on the Q&A has suggested that that progressive backdrop really doesn't apply in England and Wales at all. If anything, there's a more aggressive backdrop. Can you just speak a bit about, I mean, you already sort of said that the presumption possibly hasn't had the desired impact because of things like credible alternatives. So can you just give me a sense of what you would advise us, who maybe are in an even less progressive place than you are in Scotland?
Yeah, I think it's definitely a much more challenging context in England and Wales, given the last sort of couple of decades of policy generally, and I think the Scottish government, like love them or loathe them, have made some changes, I think, that have sort of benefited certainly the justice system. I think in that difficult context, I suppose the reassuring thing I would hope and should be that I think if you were to look at practice and sentencing currently in England and Wales, and in terms of the provision of alternatives to custody, I'm sure there's really good examples out there of magistrates and judges engaging with probation services, with local services, with support services to actually adopt those approaches that, as Cyrus points out, are the ones that actually make the difference. So I think the focus sometimes on policy making is very much at the top. What's this legislation, or what's the government done to change things? But you can have a whole ecosystem of practice and people understanding it and getting it and working differently sitting underneath that. So I think part of the challenge and part of the way you make it successful, I suppose, is you find those examples and you amplify them where you can, and you help create the conditions across the country that will support that kind of approach being adopted in different parts of the country. And that's certainly one of the things Community Justice Scotland tries to do through our support for local areas. So I think that would be one thing I would say, is to look for the good examples, amplify them, and see what transferable learning there is, but also what you can do through, whether it's funding, whether it's training, whether it's support, whether it's engagement with the judiciary, what you can do to try and help push some of that forward. Because, as I say, there's lots of reasons to not give a custodial, or not give a custodial, but there's equally as many and sometimes more pressing reasons why they might think they cannot give a community option. So I think trying to shift some of the understanding of that and trying to show, well, actually it can be done safely, effectively. And I think that effectively for me is a key point. It's going back to your question to Cyrus, but what do you say to those people with the prolific offenders, with the very long people who have had a very long list of charges over the years? Well, clearly we can see that prison doesn't work. It's not efficacious. It doesn't get people out of a cycle of offending. It doesn't deal with their issues. And we see that in Scotland, 75% of all returns to prison, or sorry, 75% of all admissions to prison are returns to prison within a year of release. So there's and of those, I think 60, or as an overall percentage, something like 60% of people admitted to prison in a year have been out in the last year, having served a sentence of less than a year. So it's not working clearly. It's compounding issues, and it's creating this sort of churn that does no one any good. The people that are caught in the system are in and out and suffering. The judiciary, police, prosecutors are frustrated because they're seeing the same people again and again. So we're sort of left with no other option but to try and do things differently. So so I think that doing it differently and finding and amplifying those ways where it's happening at the minute is one way of doing it.
And one of the things that I think you both sort of mentioned in your comments was the increased use of out-of-court disposals in Scotland. And I'm interested because the comment you made about kind of street level bureaucrats is interesting. Like, has that been an intentional policy direction, or has it just been people have got more comfortable with the idea of out-of-court disposals and are using them more? So in some ways, like, is that part of potentially an answer to our prison population problem outside of the presumption? I'm just interested in both your views on that. I'm getting nods.
Do you want to?
Yeah, I think it's definitely a part of it. To the extent to which it's a conscious policy decision, I think is debatable. I think there's sometimes a bit of smoke and mirrors with this sort of stuff, where I think as a government, the Scottish government quite likes to say, well, a sentencing issue. It's independent courts. We have no say on that. Or likewise, prosecutorial decisions by the Procurator Fiscal in Scotland. They're independent. We don't get involved in that. But at the same time, there's a clear steer and a clear narrative, and within those structures, there are ways of influencing some of that to make those out-of-court disposals more likely. So certainly in Scotland, we've seen increased focus on diversion from prosecution in recent years, both at a kind of Crown Office policy level, but also at a Scottish Government level, funding and bits and pieces of money being made available to support those kind of things. So I think that's definitely part of it. And I think generally the evidence is pretty clear that if you can keep people out of the system and get them into the support services they need, that makes a substantial difference, rather than sort of letting the logic of the system escalate you up to a prison sentence. But obviously it's not without its own challenges, and there are political difficulties within that, which I think is something that we've seen very much in the last 3 years in Scotland in particular, where a slightly as we'd say, a government on a sugary peg up here. It's been racked by scandals. The criticisms are rising in recent years, and the old soft justice, look at them letting the crumbs off kind of line from certain sectors of the political world is rising. So that it's an approach that's not without political risks, and that can cause some challenges, I think, for that. But it's definitely, I think, part of the problem, because you don't reduce the prison population or stop offending by putting people into prison. It doesn't work.
Cyrus, did you want to add to that?
Yeah, briefly. It has been a deliberate policy intention. It was part of summary justice reform from 2008 onwards. Absolutely, it's been part of the view of let's push things down. It's the same in England and Wales, same in many countries. Is it a good thing? I think there are pros and cons. It's sometimes described simply as diversion, and as Chris said, keep people out of the system, but it doesn't always keep people out of the criminal justice system. What it does is simply keep people out of court. That's not necessarily the same as keeping them out of criminal justice, as you know, Chris. So, and what can happen, how effective some of those measures are, I think, is something we really do need to examine. Effective in a number of senses. I mean, people, even at low levels, do need to see and expect to see some kind of calling out of some sort of censure, if you like, calling out of the wrong, the harm the person has committed. Victims rightly expect to see that as well. And that can sometimes be a problem with some of those measures, depending on what they are. Right. There are all sorts of issues around enforcement as well. It's worthy of another seminar, I'd say. Yeah, Phil, okay. Definitely.
Well, talking about other seminars, I'm aware that we have basically run out of time. That has been a fascinating discussion. There are loads of questions in the chat that we haven't been able to get to. You've also been nominated, Cyrus, to become the new Justice Minister by one of your fans. So, that's not a bad outcome for the start of 2024. So can I just thank you for your contributions, thank Miranda and Lucy and my team for helping arrange the event and curating it so well. There's questions we didn't get to. I will try and pass them out to Cyrus and Chris and see if we can provide you with responses. Just to say, we are also at the Centre planning a separate Export Voices event for later, we hope, in this month, looking at the presumption against short sentences, but it's particularly its relevance for women in the justice system. So please watch out for announcements about when exactly that will be. And as mentioned, the presumption is part of the sentencing bill that's currently going through the House at the moment. As some of you will be aware, that is actually one of 3 criminal justice bills going through the House at the moment. So just as a short plug for our own work, our latest briefing out today, Doing More with Less, Criminal Justice Demand and the 3 Bills, a new briefing. We consider those 3 bills currently before Parliament and try to produce an estimate of the impact we think they'll have on prisons and probation specifically. So we will send that out as a briefing to all of you on this call. So yes, thank you to our speakers. Thank you to Miranda and Lucy. Thank you all for attending. I hope that's been useful. As I said, where there are questions that have gone unanswered, we will try and either provide answers ourselves or frankly go to the experts because they know better. But from me, thank you very much for attending. Thanks to our speakers, and I hope you all have a great January in 2024. Cheers. Thank you very much, everyone.
Thanks, everyone, for attending.
Okay.
Thanks
Cheers.
very much.